Hi, my name is Chelsea West. I chose to research the Supreme Court decision Riley versus California. Some background on this case. On August 22nd, 2009, David Riley was pulled over in a traffic stop for expired tags, and they also found he was driving on a suspended license. Therefore, they had to impound the car, and when you impound a car, police officers have to search it, so they were searching it and found two firearms that initially caused his arrest. And they took his cell phone upon arrest and found evidence on his cell phone that suggested gang affiliation. Now, the firearms they suspected were linked to a gang murder that had happened on August 2nd of that month that they suspected Riley was involved in. He was a part of the Lincoln Park gang in San Diego, and they suspected that he had something to do with this. So he was taken to trial, charged, and after he was convicted, he motioned to suppress the cell phone evidence because they found it violated the Fourth Amendment. Now later, the Supreme Court would review the decisions of his trial and his subsequent appeal. Additionally, this case is also involved with Brima Worry's arrest. So Riley versus California combines two cases. Worry was arrested for being involved in a drug deal. He had two cell phones on him. When they took his possessions, police found evidence from his cell phone, and it linked to where his home was, so they used the cell phone evidence to get a warrant to search his house. So that is the other side of this case. Now, the Supreme Court found that the evidence used in these cases violated the Fourth Amendment rights, like I mentioned. Digital data evidence in these cases were not an exception to warrantless searches, which warrantless searches, the two exceptions are if an officer's safety is at risk or preserving the evidence is at risk, but neither of these were a risk with the digital data found on these phones. Some impact to the community and the criminal justice field with this case has to do with privacy for citizens and constructing a guideline for law enforcement, because privacy is a big deal to the U.S. and our forefathers. Data on a cell phone is a huge invasion of privacy because of how close we are to them, and it's important to respect citizens' privacy and to follow guidelines. I liked this quote. Although an individual's privacy rights are diminished once arrested, it should not be treated as a complete deprivation, because I feel like, yes, people put themselves in situations where their privacy is diminished when they commit criminal acts. However, they are still a person who has rights, who fall under the Fourth Amendment, and so we should continue to respect that. Now that kind of flows into my thoughts on this case. I believe that searchless warrant exceptions are reasonable, and cell phones should rarely be the exception for this, because I believe there are cases where law enforcement needs to search a cell phone or similar device. However, I think that is a very small amount of cases, and that officer safety and preserving evidence is not often at risk. With cell phones, there's a variety of ways to preserve evidence through cell phones, shutting them down, turning off the carriers. There's multiple ways, but they're not often putting their safety in the way. I think this was a good decision because upholding the Fourth Amendment is important and continues to respect levels of privacy that we are striving to maintain in the states. Nowadays, we allow a lot of people to have a lot of access to our lives, but also we don't have control over some things. Sometimes anyone can look you up and find things out about you through family members or simply through Google. So I think privacy is a super important thing that we need to continue to strive to uphold and respect. Thank you for listening in, and I hope you enjoyed.